order. We do have a busy day. This is a busy time of session. So we're going to open the hearing on Senate Bill 204, requiring the case and warrant information be sealed in criminal and juvenile offender cases. And with that, a brief from the reviser.
Thank you, Madam Chair. Senate Bill 204 amends KSA 60-2617. This is the statute that provides for the sealing and redacting of certain court records. Current law there provides that process for sealing and redacting of records, and this bill would add a new subsection A, which would provide that upon the filing of a criminal or juvenile offender case in which an arrest warrant is being sought, the case shall be sealed until that warrant has been executed or a request for the warrant is denied. Nothing would prohibit disclosure to law enforcement for the purpose of executing a warrant. Also, all subpoenas issued in a criminal or juvenile offender case shall be sealed and shall only be unsealed if the court makes a finding that unsealing such subpoena is in the interest of justice. These new provisions would be applied retroactively to any case or warrant information or subpoenas that are currently pending. And then a definition of seal is added, which would mean that no information related to a case, warrant, or subpoena, including its existence, shall be made available to the public. And I can take any questions.
Thank you. Any questions? Not seeing any, then we do have a busy schedule today, so I'm going to ask that our conferees limit their testimony to 4 minutes. And please look for the indication from me using the folder that you have 1 minute remaining. Thank you. With that, then, we will invite Steve Howe, District Attorney from the 10th Judicial District, which is the district where I am from, our ranking minority is from, Senator Rose as well. Please introduce yourself and welcome to committee.
Good morning. Steve Howe, Johnson County District Attorney. It's a pleasure to be in front of all of you, and thank you, Senator Warren, for the opportunity to be here today on our tight schedule, and also thank you, Senator Corson, for your help as well. This is an important bill that basically plugs some holes from issues created from the new statewide court management system called Odyssey, and I know you've all heard that before. Prior to that going into place, a number of us prosecutors had identified some issues related to this court management system, and one of them was related to warrant information that was being made available to the public to see. You passed a statute a long time ago, or your predecessors did, that precludes release of warrant information because it poses, of course, a threat to victims as well as law enforcement if the bad guy knows that you're coming to pick him up on a warrant. What we found was that the Supreme Court had ruled that while you don't have the actual warrant disclosed, all the other information like the criminal charges, the victim information, and all the things associated with the case is public. So you don't have to be a rocket scientist to figure out that I have a warrant for my arrest and therefore I need to take action to avoid law enforcement. So we brought this to the court's attention. The court said that they didn't feel like that statute was specific enough about what was denied to be available to public access. This bill is to close that gap, to protect victims of violence and also law enforcement. Another reason is it protects the general public because many times people who have warrants for their arrest run from law enforcement, and many traffic fatalities are as a result of individuals running who have warrants. The second component of this bill is for subpoenas. I was not aware of this, but once we got into the Odyssey system in November here in Johnson County, we found out that all subpoenas and information related to subpoenas was made available to the public. And why that's concerning is victims of violence having their name and address listed. We have to put that on a subpoena to serve them. And then if they have been injured, we have to ask for medical records, which has their date of birth or their social security number on it. Again, very concerning and something that we try to avoid putting in public documents. Or in situations where it's a white-collar case and we're asking for banking information, we have to list the bank account number in order for the bank to produce the records for us. So all of this is to close the gaps, to protect people's personal information, to protect law enforcement and victims of violence on warrant information. There is no real cost associated to this. In talking to OJA, literally all they have to do is go from making it public to non-public. It's a literally flip the switch in their system to change that, is what my understanding of how Odyssey would then work. So if you look at the proponents, our two largest domestic violence shelters in Wichita and in Johnson County are supportive of this. MOXA, that helps support victims of sexual assault, as well as Sunflower House, who couldn't get their statement in, but is in supportive of it. This is not a political bill in any way, shape, or form. It's a public safety bill. My neighbor, Mark Dupree, the DA from Wyandotte County, is very supportive of this bill as well because of the potential impact. So I would ask that you pass this bill, not only pass this bill out, but pass it today, so we can correct the problems through the Odyssey system. If you look at the safe home testimony, just in the short time that we've been on Odyssey, victims are already terrified and having to move their addresses because of this. This is a situation, there's no hidden trap doors here for all of you. This is a win-win for the people of Kansas and also for the victims of violence. And so I'd ask that you approve of this bill. It's a common sense approach to plug those holes. And that concludes my testimony, to be under the gun there. And I'd be happy to answer any questions that any of you might have.
Great timing. So thank you for your testimony as well. We're going to reserve questions till we've heard from all the proponents, if you have an opportunity to stay.
Yes, I do.
That'd be
great.
great.
Thank you, Chairperson.
Thank you. And I meant to introduce Mr. Howe as a proponent conferee, but want to next introduce Josh Stewart, Senior Assistant District Attorney, on behalf of Mark Bennett, District Attorney from the 18th Judicial District, and no, he's not present, so he is, so thank you. Yes, so please introduce yourself and welcome to committee. Right.
Senator, I'm actually here for Senate Bill 203 to be a proponent for that bill.
Okay.
I'm sorry.
Then do we have, I thought you were here, I'm sorry, for Mark Bennett on both bills today, so.
No, thank you, though.
Okay, great. So then we do have Mark Bennett, District Attorney, 18th Judicial District, on WebEx today. So please introduce yourself and welcome to committee.
Thank you very much. I appreciate the opportunity to be here. And I'm sure Josh could have done a nice job for me if he'd have stood in for me. I heard Steve's comments a moment ago. I'm not going to belabor the point. This is a very simple bill that would fix a couple of holes in the system that we learned about when Odyssey went into effect. The ability to not allow warrant information and active warrant information to be public, as well as the fix with regard to the subpoenas, and then the final subsection 3, I believe it is, that makes us retroactive. I think this is, as he said, a very simple bill that would simply effectuate and improve public safety across the state of Kansas. I don't see a downside to it. I can't conceive of a political way to spin this. The last thing I would say, I don't know that Steve did mention, is this would in no way limit defense counsel's ability to get this information, or the prosecutor's ability to get this information. If counsel for either side issues a subpoena, that information would still be shared by way of Brady and the discovery statutes. So this isn't going to limit anyone's access to their due process rights, anything like that. It's simply to keep it out of the public arena. So as Steve said, witnesses' addresses, information, Social Security information, things like that, the type of things that we in every other regard keep safe. This would simply allow the state to be explicit that this is information that needs to be kept safely. So I know you're tight for time. I will stop talking instead of just reiterating the same thing Steve said over and over again. I simply wanted to be here today to reiterate my support for this bill and let you know that I think it is in fact a good thing for the state of Kansas. Thank you.
Thank you. And next we will hear from Ed Klump on behalf of the Kansas Sheriff's Association. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. Ed Klump, and I am here today representing the Kansas Sheriff's Association, not the other two that I frequently am here on. We support this bill for all the reasons the district attorneys have talked about. I'm going to cut right to the chase. We are asking for an amendment to it. If you look on page 1 of the bill on lines 11 through 13, where it says nothing in this paragraph shall prohibit disclosure of case or warrant information to law enforcement for the purpose of executing such warrant, we're asking for the same provision to be put on subsection A2 on the subpoenas. The sheriffs need access to that to enhance their ability to serve those subpoenas as well. And Madam Chair, I shared this with the reviser, and we had a proposed language to do that. And as revisers frequently do, they have a better way to do it that we support. And I know they have an amendment ready if you work this bill. So I'll stop there and answer questions when it's appropriate.
Thank you, and everyone has done a great job with not only the testimony, thank you, but with the 4 minutes. So do we have any other persons wishing to testify as proponents on the bill? Not seeing any. Committee, you'll have at your desk proponent written-only testimony from Julie Donelon, President and CEO, Metropolitan Organization Countering Sexual Assault, Amanda Myers, Executive Director, Wichita Family Crisis Center, and Heidi Wooten, President and CEO, Safe Home. And with that, we'll open it up for any questions. Senator Shane.
Thank you, Madam Chair. This question is for District Attorney Howe.
And please introduce yourself again when you answer. Thank you. Well, not yet, but.
Thank you, Madam Chair. So, Mr. Howe, we've heard from bondsmen quite a bit, actually just last week. And I'm wondering, it seems to me that the current bill would prohibit or limit access to bondsmen from accessing warrants that might impact their ability to recover folks. Is that something that you see as being an impact of this bill, and would you be okay with addressing that?
They would have access to that
Go ahead and introduce yourself. I'm not sure that was microphone. Just trying to keep a clear record is all. So thank you.
I apologize, Chair. Steve Howell, Johnson County DA. This is only when the case is initiated. And so once the case is initiated and the person is actually arrested, then they can seek bond. And then the information becomes public. And so it's a very short time period that information would be precluded from being viewed. And that is from the time that the warrant is executed by the judge and the time that it's served on the defendant and they're arrested. Once that happens, then the information becomes public again. And so that would allow the bondsman to have that information so they can make the proper determination. So I don't think that necessarily precludes them from doing their job.
Thank you. I'm glad Senator Shane raised that question. I have a similar question for the defendant and the defense counsel to have information about who certain witnesses might be that the defense might need to talk to in preparing the defendant's case. But you had said that once the warrant has been executed, then the information becomes public. Is that right?
Yes, both the warrant information and the subpoena information, that all becomes part of, as Mark Bennett talked about, part of the Brady requirements, and that is available to the opposing counsel and the defendant.
Okay, thank you. Other questions? Not seeing any, then thank you very much. Appreciate
very much.
Your testimony. Committee, we have a request now for any neutral or opponent conferees wishing to testify. Not seeing any, then want to draw your attention to, we do have neutral written-only testimony from Michelle McCormick, Executive Director, Kansas Coalition Against Sexual and Domestic Violence, and opponent written-only testimony from Shane Rolfe, Vice President, Kansas Bail Agents Association. So with that, then, we will close the hearing on Senate Bill 204. We will next open the hearing on Senate Bill 203, authorizing a notice to appear to be issued for an unavailable witness or a material witness. And with that, a bill brief from the reviser.
Thank you, Madam Chair. Senate Bill 203 amends a couple of statutes. The first is KSA 222805. This is the statute that allows a court to require a material witness to post bond. A new provision is added here saying that if a person was personally served with a subpoena, the court would be authorized to issue a notice to appear to a charge of indirect contempt of court pursuant to KSA 20-1204A. When that witness does appear, then the court would be authorized to continue that charge for the duration of the proceeding and order the witness to comply with any conditions that the court deems necessary to secure the presence of the witness. Section 2 amends KSA 6459. That's the definitions that apply in the hearsay rule. Current law provides there the situations where a witness is considered to be unavailable. This would add that a witness is considered unavailable if the witness has failed to appear as directed in this new provision in KSA 222805. And I can take any questions.
Thank you. Any questions? All right, then. We will then invite proponent conferee Josh Stewart, a Senior Assistant District Attorney on behalf of Mark Bennett, District Attorney, 18th Judicial District, and the Kansas County and District Attorneys Association. Please introduce yourself and welcome to committee.
Thank you. My name is Joshua Stewart. I'm a Senior Assistant District Attorney in Sedgwick County. I am here on behalf of Mark Bennett and KCDAA. Madam Chairwoman, members of the committee, thank you for the opportunity to be here and to speak in support of this bill. It may seem a little strange to hear a prosecutor speak in favor of a bill that gives me the option not to have someone arrested, but as a prosecutor, I can say honestly that my first priority is to see that justice is done. I've been a prosecutor for about 15 years, and the majority of my career has been focused on domestic violence, sex crimes, and crimes against children. The first thing one learns in this area is that victims of crime, true victims of crime, violence, and any other type of abuse at the hands of a loved one frequently become uncooperative with the justice system. While many people may find that hard to believe that a true victim would not want consequences for her abuser, experience and research reveal that this behavior is entirely rational. The logical option for many domestic violence survivors is to recant, to minimize, or simply not to appear in court when faced with the possible loss of a home, children, familial support, or simply threats that the worst violence is yet to come. When a victim of crime fails to appear in response to a subpoena, it is often just and prudent to have that person arrested to ensure his future appearance in court, and current law allows that. In fact, as the law stands now, that is really a prosecutor's only option, unless the prosecutor just simply wants to drop a case where somebody has been victimized. When a victim of crime fails to appear because she is threatened not to with physical, financial, or emotional abuse, arresting her is not justice. Senate Bill 203 gives a prosecutor a gentler option that does not expose a victim to the embarrassment, the hardship, and collateral consequence of immediate arrest and incarceration. Further, this bill will prevent otherwise productive members of society from losing jobs, homes, and savings unnecessarily. Children will not have to be placed in protective custody because their mom or their dad is in jail. And we avoid all of the knock-on effects that leads to. Further, our overcrowded jails won't have to bear the costs of another inmate. This bill makes financial, judicial, and moral sense. I know that we're on a tight deadline today, so I would ask the committee to go ahead and work this bill today. And I stand open for any questions, and I appreciate your time. Thank you.
Thank you. Committee, any questions? Not seeing any, then thank you. And is there anyone else wishing to testify as a proponent on the bill? Not seeing any. Do we have anyone wishing to testify neutral? Not seeing any. Then we will hear from opponent conferee Lindsay Ford and Emily Brandt, BIDS Legislative Committee, Kansas Board of Indigence Defense Services. Please introduce yourself and welcome to committee. Are we sure your microphone is on? Is the light on?
No, it was not. There we go.
Okay, great. Go ahead and start over.
Thank you. Hi, my name is Lindsay Ford. I'm with the BIDS Legislative Committee, and we are here today in opposition of Senate Bill 203. For those of you that I've not met previously, I am a trial attorney in the Wyandotte County office. Prior to becoming a public defender, my experience was as a public policy advocate for domestic violence, sexual assault victims. I have almost 13 years experience advocating for individuals going through the criminal justice system. And kind of the through line of all of that work was a respect for and deference to the decision-making of the individuals affected. We tend to look at situations like public safety, broader policy issues as larger systemic problems. And when we're talking about situations like this one, like the proponents outlined, it's still most important to look at those from the position of the individuals actually involved and affected. And this bill would serve to strengthen the state's ability to substitute its own goals and objectives for those of the individual people whose lives are affected on a daily basis by the criminal justice system. Now, I'm not going to belabor all of the points in our written testimony. We had 3 big ones. I think it's very important to draw everyone here's attention to the due process considerations, not just for our clients, those charged with crimes, but for the victims, witnesses, the individuals that the prosecutors might seek to impact here. I understand the indirect contempt option is being listed as an alternative to potential incarceration, but it is still exempted as written from representation being appointed for someone facing an indirect contempt charge. And one of the potential conditions that they could be looking at would still be that possible incarceration. Sometimes trials can last days, weeks, even months, and the idea that somebody could be jailed without representation for any length of time is problematic, concerning all of the terrible things that we don't want in our system. Additionally, expanding the definition of unavailable to someone who is just not present or who fails to appear, I mean, it has a lot of considerations that go much further than maybe even the state, or I'm sorry, the proponents intended in this situation. The implications to confrontation are huge, and again, they're detailed in the written testimony. And then again, lastly, this seems to create a kind of secondary process to the one that already exists that could potentially limit or extend, I'm sorry, the amount of time it would take to get a case to trial, which major considerations on that front as well. For all of those reasons, we are in opposition, and we would ask you to not pass this bill. Thank you.
Thank you. Is there anyone else wishing to testify in opposition to the bill? Not seeing any, then we will open it up for any questions. Senator Bowser.
Thank you, Madam Chair. Ms. Ford, thank you for your testimony today. I just want to make sure I'm understanding your position here. Are you asserting that if, I guess, is your concern that if a victim is not able to post bond, that they'll be detained?
Please introduce yourself again. Thank you.
Yes, Lindsay Ford with the BIDS Legislative Committee, and yes, that would be the concern, and especially if this new subsection is exempted from the part that requires appointment of counsel, they would be potentially detained without any sort of representation.
Thank you. Committee, other questions? Not seeing any, then we will go ahead and close the hearing on Senate Bill 203. That leaves us some opportunity to work some bills that we have previously heard. So I'm going to bring some of those up in just a moment. Thank you. Committee, we're going to pull up Senate Bill 241, and we heard Senate Bill 241 on Friday, and we're going to ask for a brief summary from the reviser. It's regarding providing that restrictive covenants in certain contracts are enforceable and not considered a restraint of trade in certain circumstances. So with that, a brief reminder from the reviser.
Thank you, Madam Chair. Senate Bill 241 does amend the Restraint of Trade Act to add those 5 new provisions where certain covenants described in contracts would be presumably considered not a restraint of trade. And it also provides some language on how to interpret certain covenants and contracts. And I can take any questions.
Thank you. Committee, questions? Senator Shane.
Thank you, Madam Chair. Ms. Scott, could you just quickly comment, would this be retroactive and impact agreements made in the past, or would this only impact agreements made in the future? Thank you.
Ms. Scott.
Thank you, Madam Chair. Retroactivity is a decision that is left up to the courts. You all, as the legislature, have the ability to say in a particular piece of legislation that you intend for something to apply retroactively. That is not present in this legislation at this time, but ultimately, even if you put a provision in there like that, retroactivity is usually something that the courts make a determination about.
Thank you. Other questions for the reviser? Any discussion or a motion? Senator Titus.
Thank you, Madam Chair. I would move the committee pass out or recommend favorably for passage Senate Bill 241.
Thank you. Is there a second? Second from Senator Argabright. You all have heard the motion. Any discussion? All right, not seeing any. Would you like to close on your motion?
I close.
Thank you. You all have heard the motion. All those in favor signify by saying aye.
Aye.
Those opposed, no. The motion passes. Thank you. Next, we are going to take a look at Senate Bill 222, and that we also heard Friday. That concerns prohibiting deference to a state agency's interpretation of a statute, rule, or regulation or document by a state court or an officer hearing an administrative action. So with that, a brief reminder from the reviser.
Thank you, Madam Chair. As the chair indicated, this legislation would provide guidance to both courts and administrative hearing officers when they are interpreting a statute or a rule or regulation or other document from an agency to provide that deference shall not be given to the agency's interpretation, and they should review that issue de novo or from the beginning.
Thank you. Committee questions for the reviser? Not seeing any. Is there discussion? I think we heard some robust testimony and some discussion when we heard this on Friday, and some concerns were brought up. So I have an amendment regarding what do we mean when we say individual liberty. So with that, I'll ask the reviser to pass that out. And I'll have the reviser explain.
Thank you, Madam Chair. The first two changes you'll see there are to add the phrase administrative hearing before officer to delineate who we're talking about, who would be making these interpretations. And then the second change there in line 16 and 17, we would strike the language talking about exercising remaining doubt in favor of a reasonable interpretation that limits the state agency's powers and maximizes individual liberty. And we would replace that with exercising any remaining doubt in a way that's consistent with an individual's fundamental constitutional rights.
Thank you. And part of the reason for changing it to administrative hearing officer from just an officer, then we're not talking about, for instance, inside our prisons, and if there's some law enforcement regulations inside of our prisons, that those aren't impacted, but these would truly be administrative hearing decisions interpreting rules and regulations and statutes as being enforced by our departments or agencies or boards. So that kind of helps with the concern that, well, what if we're talking about regulations inside a prison? So it helps clarify which arenas that the bill would apply to. Is there a second to the motion? Yes, Senator Rose, thank you. Any discussion? Not seeing any, then I will close on the motion, and you all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. We are back on the bill. Committee, are there any other discussions, or is there a motion? Senator Haley.
I don't have a motion, Madam Chair. Thank you. I was kind of constrained a bit by the neutral testimony that was brought, I think, by Board of Healing Arts. They were concerned about the Word document and how it would apply to their particular administration. I'm trying to find my notes. I had a note on the other, but I didn't know if that had been a consideration that the chair or members had given to the Board of Healing Arts in terms of, I think they were saying that they were concerned how that could be interpreted, the Word document could, and I apologize that I don't have that in front of me wherever it is, but I did have that in my notes and thought that if it had struck anyone else's attention, that I would at least raise it prior to a motion to move the bill out.
Thank you. Any further discussion? Not seeing any, is there a motion? Senator Shane.
Thank you, Madam Chair. I move that we move Senate Bill number 222 favorably as amended.
Thank you. Is there a second? Senator Klemp. Any further discussion on the motion? You may close.
I close.
Thank you. Committee, you all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion passes. Would anyone like their vote recorded? Okay, thank you for your work on that. Next, we are going to take a look at Senate Bill 237. If you'll remember 237, we also heard on Friday requiring the court to consider the value of retirement accounts if a person loses income for certain reasons, and eliminating the exemption of pension and retirement monies from claims to fulfill child support obligations. With that, a brief from the reviser.
Thank you, Madam Chair. Senate Bill 237 makes primarily some changes in the family law code to say that if you have a loss of income because of criminal activity or professional misconduct or voluntary underemployment, you can't get a modification of your child support order to modify that amount downward, and also the monies in your retirement accounts can be used until that, to maintain that present obligation that you're under until either the money is exhausted or you come up with some other way to pay.
Thank you. Committee questions for the revisor? Not seeing any. If you'll recall, we had some neutral testimony from Mr. Conroy with CAPERS and had some concerns about how that would affect CAPERS funding and other, well, CAPERS funding mostly. So work has been done in coordination with CAPERS, and we have an amendment that addresses the concern. And if Natalie will pass that out, that'd be great. Thank you. Would the revisor please explain the amendment?
Thank you, Madam Chair. So you'll see on page 1 there in subsection B, we're limiting this to instances in which a parent has accumulated a child support arrearage, and then upon the occurrence of a distributable event that would be defined by the terms of that retirement plan, the use of the money in those plans would be able to use to pay that arrearage with a one-time lump sum distribution. And then over on page 2, you'll see where we said that those claims for child support against that retirement plan would be required to take priority and not be subject to early withdrawal penalties. Those provisions are stricken, and they're replaced with provisions saying that claims for child support against those individual retirement plans would not require a plan to make any distributions that are not otherwise authorized by the terms of the plan, and also they would be subject to early withdrawal penalties and taxable income as a distribution. And then the last change on page 3 is just a typo technical change.
Thank you. Committee questions or discussion? So you'll note that regarding the hearing on this, DCF did submit some opposition testimony, and it has been confirmed with DCF this morning that with these proposed changes, it addresses their concerns. Okay, no, okay. Okay, sure, yeah, that was different than what I had heard, but go ahead.
Thank you, Madam Chair. I can just, Madam Chair asked me to share this amendment with them to comment on that. And their comment was that DCF has no concerns with the proposed amendments. However, the agency would still ask the committee to exercise caution regarding the proposed change to prohibit modifications for incarceration or criminal conduct, as it would put DCF in direct violation of federal regulations and threaten federal funding.
So that's regarding the incarceration part, which is not addressed in this amendment. So that's why. Okay, so they don't oppose the amendment that we have in front of us. So, okay, great. So with that, is there a second on the motion? Senator Rose. Sorry about that. Any discussion? Not seeing any, then I will state that this gets us in compliance with CAPERS, with the IRS, and still allows for that one-time lump sum payment for child support arrearages that you have been found to, you owe the child support amount, you haven't paid them, you haven't kept current, and this would address getting those resources that were intended to be for the kids. So with that, I close on my motion. You all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries, and we are back on the bill. So with the incarceration issue and modifying for that reason, it looks like we still have some opposition for DCF. It's something that if the bill would be moved, we're up against a timeline. We can if there's an amendment to address that, we could possibly come back to working the bill stand in recess today to give the reviser time to draft that amendment and come back at 5 o'clock today since we're up against a turnaround deadline. Or we could move the bill out, if that's the will of the committee, as amended, and could possibly discuss amending it with that change on the floor. Or if the bill were to advance and get over to the House could take a look at putting that amendment in as well. So I would hate to hold up the advancement of what otherwise, to this committee, at this point might look like good policy for the state of Kansas, but to hold it up because we're up against a time frame deadline. So any discussion on that, the will of the committee? Yes, Senator Haley.
With that insight that you've shared procedurally, Madam Chair, if it were to move, since this is our last day, I don't know how many want to reconvene at 5 for this one amendment, but if we moved it out just without recommendation, which would then leave the question that, though it's been already addressed, that there is some more or further work that potentially might be done by the Committee of the Whole.
Thank you. And again, the DCF, it's really a policy question for the legislature. So if the legislature wants to leave it in that if you're incarcerated, you shouldn't be able to decrease the amount of child support that you owe your kids, then can simply pass it out and wouldn't need to consider further amendment. So is there discussion or thought on that? Senator Rose.
Thank you, Madam Chair. Every bill has a story. And the story behind this bill is a destitute woman who's trying to take care of her kids and ex-husband not paying child support. Meanwhile, ex-husband has, say, $1 million in a 401k. And so I think that we need to be mindful of that. And so I support this bill as amended.
Thank you. Committee, other discussion? Not seeing any, then is there a motion to move the bill out of committee? Senator Rose.
I make a motion that we move this Senate Bill 237 out of committee as amended favorably.
Thank you. Is there a second? Senator Reichman. Any discussion on the motion? Not seeing any. Senator Rose, would you like to close?
I close.
Thank you. You all have heard the motion. All those in favor signify by saying aye.
Aye.
Those opposed, no. The motion passes. Committee, it's not our usual practice, but since we are up against a time deadline with turnaround, I wanted to bring up a bill that we heard today, and that would be Senate Bill 204. It's not our usual practice to work a bill the same day that we hear a bill. However, again, with our shortened session this year and with our turnaround deadline, Senate Bill 204, and you'll remember it is requiring the case and warrant information be sealed in criminal and juvenile offender cases. And with that, just a reminder from the reviser.
Thank you, Madam Chair. The bill would provide that on the filing of a criminal case or juvenile offender case where an arrest warrant is sought, that information shall be sealed, except it can be provided to law enforcement to help with executing the warrant, and then subpoena information in those cases would also be sealed.
Thank you. Committee, any questions for the reviser? Any discussion or a motion? Senator Titus.
Thank you, Madam Chair. I have an amendment. Natalie would pass that out. The essence of the amendment is that it would make both the warrant and the subpoena information available to law enforcement so that they can carry out their duties. Mr. Klump testified to this effect earlier today.
Thank you. You've explained your motion. Do you need the reviser to explain it as well? Nope. Okay, great. Is there a second on the motion? Senator Bowser. Any discussion on the motion? Not seeing any, then would you like to close?
I close.
Thank you. You all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion passes. We are back on the bill. Is there further discussion or a motion? Senator Bowser?
Thank you, Madam Chair. I make a motion that we move Senate Bill 204 favorably out of committee as amended.
Thank you. Is there a second? Senator Klemp, any discussion? Would you like to close?
Closed.
Thank you. You all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion passes. Committee, I'd like next to take a look at Senate Bill 54. You'll remember Senate Bill 54 is a bill we heard last Monday. And Senate Bill 54 is limiting discovery and disclosure of third-party litigation funding agreements in certain circumstances and requiring reporting of such agreements to the Judicial Council for study. With that, a brief reminder from the reviser.
Thank you, Madam Chair. Senate Bill 54 creates that test for the court to weigh whether discovery should be allowed of third-party funding agreements, both the existence and the content of those. And then it also requires reporting of those to the Judicial Council, and then the Judicial Council would come report to you all about their findings and any recommendations they have about the concept of third-party litigation funding.
Thank you. Questions for the reviser? Is there any discussion? There's been some discussion, I understand, between the proponents and the opponents over the weekend since well, actually in last week as well, since this was heard on Monday. So I understand that there are some proposed amendments that want to be discussed. So we don't have those prepared yet because I understand some of them were just agreed to between the parties anyway at 8 a.m. this morning. And our reviser, who has also worked diligently over the weekend and getting an amendment at 8 a.m. wasn't possible to get that amendment ready. So why don't we, I think that it's difficult to work conceptual amendments, but I would like to have some discussion on what the proposed amendment is. If we have the carrier of the amendment would like to discuss, and I think that's Senator Shane. So go ahead, Senator Shane.
Yeah, certainly. Thank you, Madam Chair. And I had provided a copy of the proposed compromise language, if that could be circulated. And I think unfortunately it reads as a clean version, and so it might be a little bit difficult to follow exactly what the changes are. But the proponents and opponents were able to engage in quite a bit of conversation and come to some degree of alignment of what would be appropriate for disclosure and discovery. And so this bill seeks to reflect that compromise between the parties, where there is some amount of a priori disclosure and also withholding relevant information that would be in the protective interest of a party that might have third-party litigation funding.
Thank you, Senator. I'm asking the reviser and research to pass out. It's not in format from the reviser, so it's not what the bill would look like if it were amended, and it doesn't contain the strike-through and the inserts, so it's a little bit difficult to follow, but for the purposes of discussion, we've passed that out. And based on what you've heard from Senator Shane committee, are there any questions or discussion? Yes, Senator Bowser.
Thank you, Madam Chair. I'll just make a quick comment here. I'm glad the parties were able to work out a compromise here, and I'll just remind my committee members that the Attorney General is in favor of this bill. And we also heard testimony that 88% of respondents want transparency in the legal process. Thank you, Madam Chair.
Thank you. So further discussion, Senator Shane.
Certainly. Thank you, Madam Chair. So I would point, if you'd like to see kind of the major changes, if you'll remember in the primary bill draft, it spoke about disclosure of the existence and the content of the agreement. And so now if you look at subsections B 1 through 6, that will identify the what would be the disclosed content as opposed to a blanket statement of content. And so item 1 would be the identity of all contracting parties to the third-party litigation funding agreement, including names, address, and for legal entities, the place of formation. 2, whether a third-party funder has control or approval rights with respect to litigation decisions. 3, whether a third-party funder has the right to receive materials designated confidential. 4, the existence of any known relationships between a third-party funder and the adverse party's counsel or the court. 5, a description of the nature of the financial interest, including but not limited to whether it is in whole or in part recourse or non-recourse. And 6, whether any foreign person from a foreign country of concern is providing funding directly or indirectly. So those are the primary components of disclosure that were agreed upon between the parties.
Thank you. Is there any further discussion or questions about kind of the proposal in front of us presented by Senator Shane? I'm not seeing any, and given that this has been presented as an agreement between the proponents and opponents, and we do have it in some written form, here's what I want to propose to the committee. It's important that we have a good record of legislation as it comes through, and in order to create that, we would have to allow the reviser time to put this in amendment format. So with this being the last day, my proposal is this, that if it's the will of at least a quorum of this committee, that we could stand in recess until adjournment of the Senate today and come back to continue to work this bill. Making sure that that gives the reviser time when we come back at that point to have it in a format where we can properly address it. Would that give the reviser enough time?
Thank you, Madam Chair. I believe so. I'm trying to check on some of my afternoon committee obligations, but I think that I'd be able to have that in time for once you adjourn.
Thank you. And is that something we could do at the rail, or we would have this room available with staff, or what would that look like? And I think this room is busy at 3:30, which might be when we adjourn. So what I'm going to do we at least have a quorum who would be available immediately after session today? I'm seeing enough heads nod yes in the affirmative. Thank you. I'm going to then, we're going to call on the floor then a meeting of, well, we're going to stand in recess. And in the meantime, we'll have research try to find a room where we might be able to meet at, if we set a time certain, is that easier? 5 p.m., is that too late for our committee, or do we still have a quorum at that point? I'm seeing that we still have a quorum. Do we want to just schedule it? I'm looking to research if that's easiest to get a room and for 5 o'clock.
Natalie Nelson from Legislative Research. It'll just be dependent upon if LAS has rooms available at that time, which they should at 5 p.m. I think it'll be easier at that point instead of any time before.
So here's what we're going to do. We're going to allow LAS to look at that, and we're going to, when I announce it, we're going to stand in recess, and I will call the meeting back to order on the Senate floor before we adjourn and announce the when and where. So try to meet before 5 p.m. if we can, and if not, then it'll be 5 a.m., but the announcement will be made from the Senate floor, if that's clear for everybody. So I'm getting affirmative nods of the head. So within, we're going to pause our work on Senate Bill 54. And before we go to recess, I'm going to make sure that we have concluded our other work for today. Just a moment. Thank you, committee. Just want to thank everyone for their work before turnaround. We worked a lot of different issues, and we'll be sending those bills to the Senate floor. And with the bills that we passed out of committee on Friday, appreciate the opportunity to put those on the consent calendar. However, with our time frame, if they were to sit on the consent calendar for the 3 days required, we would run out of time before turnaround to send them to the House. So I have worked with our Senate Secretary, and those are going to be placed on general orders, so not on the consent calendar, so that they can be brought above the line if that's the will of Senate leadership. Yes, Senator Haley.
I'm sorry, listen, pertaining back to 54 for later today, should we retain the bill, or will there be additional documents? Should we take those with us in the event we don't meet here? Should we take 54, or will there be?
I would suggest take your committee folder that you have for Senate Bill 54 in case there's not an opportunity to redistribute your folders. Appreciate that, Senator. Thank you. And with that, then, I want to thank you all for your work, and we will then be, until call of the chair, in recess. Thank you.